It's time to go into one of the most useful foundational cases for our study of the First Amendment. And that case is going to be Chaplinsky versus New Hampshire. We're going to be talking about the concept of separating out speech from conduct and developing a continuum that we can use to decide various cases. Chaplinsky is a very unusual case, even for the Jehovah's Witnesses case. Chaplinsky was a Jehovah's Witness in Rochester, New Hampshire, a very small town, and he was very provocative. His idea of proselytizing was not going to people's houses and doors. He would go to a city sidewalk, and he would just start yelling about his religion. And he would say very provocative things. He would say things like he would call them racketeers, and he would call people criminals, and he would insult their religions, and he would develop quite a crowd. And in this 1942 case, Chaplinsky started yelling to the crowd and made them so unhappy that they wanted to physically attack him. And it is said some of them actually started to do so. He created a crowd that filled up the sidewalk and filled up the street. He didn't have a permit. And the sheriff, the only sheriff in town, came up and was trying to rescue Chaplinsky from this riot that he had created. And Chaplinsky turned on the sheriff and started to say things to the sheriff like what he had been saying to the crowd. And the sheriff, though trained, though professional, was upset about this. How can you go about, as a liberal, protecting what Chaplinsky was doing? That was the challenge for Frank Murphy, who was the most liberal member of that court. We think now of Hugo Black and William O. Douglas to be the most liberal of the 1940s courts. Wasn't true. They were actually moderate liberal. The most liberal two justices on the court from 1943 to 1949 was Frank Murphy, former mayor of Detroit and Secretary of Defense, and Wiley Rutledge, a former federal judge from out in Iowa. When they looked at Chaplinsky's actions, Murphy decided, I can't protect this. Now, how do I decide this case in a way that does not do damage to the First Amendment? And this is the ingenious part of what he did. What he used was a concept that first District Court Judge Learned Hand had explored, and then Supreme Court Justice Oliver Wendell Holmes and Louis Brandeis used in a series of cases in the 1919, 1920s. The idea of the free marketplace of ideas. He argued that the notion of the First Amendment is to protect the expression of different views and to allow for open clashes of these views and to determine what is the correct or incorrect response or the truth or falsity of the response by seeing what percentage of the general listeners, the audience, the public, adopted those views. If you want your view to be accepted, it has to be tested in the free marketplace of ideas. That's his basic concept. So Murphy now looked at what Chaplinsky was doing and asked this question. What if what you're saying is not designed to promote the free marketplace of ideas? What if what you're saying is so upsetting that it does not have any worth to the free marketplace of ideas? What if what you are saying is so offensive that it makes other people want to fight you? What if what you are saying is a fighting word? And his logic was, there are certain expressions that are carved out of the First Amendment. They are not protected by the First Amendment. They are not considered to be speech, he said. They are conduct. Such expressions would be obscenity, libel, slander, certain forms of expression that are deemed by the government to be a threat to society or a threat to national security. And he's asking, if I decide that what Chaplinsky was saying was a fighting word, can I say that it is not speech, that it is in fact conduct? And can I say that it should be carved out of the First Amendment, just like those other carve-outs, obscenity, libel, slander, national security? Can I, in fact, still say that freedom of speech, freedom of religion, freedom of the press are in a preferred position, and then just say what you're doing is not freedom of speech, it's not speech, it's conduct? And he concludes that he can, and says, I have now, within my levels of scrutiny, two different types of expression. I'm going to put them on a continuum. I'm going to have protected speech, and I'm going to have unprotected conduct. Here's how he defines it. Here's his rule. Freedom of speech and freedom of the press, which are protected by the First Amendment from infringement by Congress, are among the fundamental personal rights and liberties which are protected by the 14th Amendment from invasion by state action. I am still with Douglas from Murdoch. They're in a preferred position. But, he says, there are something called fighting words. These include the lewd and obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. If you say this, and it's so offensive that it injures the other person and it will breach the peace as a result, that is a fighting word. That's not speech, that's conduct. In other words, he's saying these do not help us expose various ideas in the free marketplace of ideas. They have no value to the search for truth. And so he argues that if what you say will tend to cause a fight, it's a fighting word. I'm not going to protect it. Now, how does he solve the problem? The problem is, what about the policeman? He's no longer concerned with what's happening to the audience. If he were concerned with the audience, we would be in a completely different type of case. We would be talking about the times, places, and manners, and where he is speaking. He's concerned with the reaction of the officer. And he says the officer admitted in the trial that there were times when he felt he was so unhappy with what was being said that he wanted to strike, he wanted to hit Chaplinsky. And Murphy says if you have a trained officer who knows not to escalate a situation like that, and who is so angry at what is being said that he wants to beat up the speaker, that tells me that it's a fighting word. And that is not part of what is protected by the First Amendment. This is how he defines it. The word offensive is not to be defined in terms of what a particular addressee thinks. The test is what men of common intelligence would understand, the words likely to cause an average addressee to fight. The English language has a number of words, expressions, which by general consent are fighting words. When said without a disarming smile, such words as ordinary people know are likely to cause a fight, so are threatening, profane, or obscene revilings. Think about today what kind of fighting words there might be, if any. But in the 1940s, the kinds of things that he was saying to this officer were considered to be fighting words. Now, how does this two-part continuum help us? I tell my students that as we go through these cases, all we have to ask is what's going on in this case speech worthy of protection that contributes to the worth of the free marketplace of ideas? Is there an idea here that needs to be tested in the free marketplace of ideas that other people will want to listen to, that maybe the The clashing of these views and these interests may result in the determination of what is the correct, the right, the proper, the truthful view. Or is what this person doing so offensive, so non-contributory to the free marketplace of ideas that it is not speech, it is conduct? It's not enough to define the two ends of the continuum. Cities and towns and the national government now have to draw a line between protected speech and unprotected, regulatable conduct. And that's the problem. That's what Scalia was showing us in Brown versus EMA. What happens if your law goes too far? What happens if you are, in fact, eliminating protected speech, good speech, free marketplace of ideas contributions? If your law goes too far into the protected speech area, the court will say it is either over-inclusive or overbroad. You cannot use your law. Your law is going to be created under the power of the 10th Amendment, the power of the government to protect the health, safety, morals, and public welfare of its citizens. It's what's called the police powers. Your police powers 10th Amendment law cannot ban perfectly acceptable speech. That would be considered to be over-inclusive or overbroad. But what if the error you make is a different error? You don't go far enough. There are certain kinds of bad conduct, bad expression that should have been banned but weren't. So your law doesn't get to that line between speech and conduct. That's considered under-inclusive or underbroad. If there are types of expression that you should have banned but didn't, that's where we're going to say the law is a violation. And what Murphy is doing here is he is creating another kind of expression that is regulatable conduct. He's adding the concept of fighting words, and he's saying your law may now ban fighting words. But don't go so far as to say, if you just hurt the sheriff's feelings, or if he felt bad, or he was a little depressed because of it. That's not what Murphy's saying. That officer has to be willing to fight the speaker. That's when it's a fighting word. So if you talk about lowering the self-esteem of a police officer, you've gone too far. You're over-inclusive. So we're going to see the modern court, especially the Roberts Court, rely on this concept of looking at the law carefully and saying it can't be over-inclusive or overbroad. It can't be under-inclusive or underbroad. It has to be just right with the three bears, just right. Now, it gets a little more complicated than that because these laws are written about certain types of speech. They give you categories of speech. And what I've just described to you is the concept of a law having to be closely tailored or narrowly tailored. It's the idea that that government has to write that law so that only bad speech is banned and good speech is protected. And one of the mistakes that a law can make is there are certain categories of people, certain categories of groups that are not protected by this law. Or there are certain categories of groups that should be protected, but the government is not including them. You maybe fail to mention the group, or you mention the group and you shouldn't have mentioned it. This kind of approach leads to a different technique called content neutrality. Content. You look at the law, you ask who's actually being regulated, and you ask, should they be regulated? And you want to make sure that everybody is being treated the same if they deserve the same treatment. You have to have a reason for why you include some groups and why you don't include others. And so we see the court sometimes using over-inclusive and under-inclusive, and sometimes using the content discrimination of the law, or demanding that there be content neutrality. Well, I hope I haven't confused you yet, because there's one more concept that they'll use. What if you do everything right? What if the law you have covers the people that they should and doesn't cover the people that they shouldn't? So it's content neutral. What if the law that you have is not over-inclusive? You have not banned good speech. What if the law you have is not under-inclusive? You have not left out any conduct that should have been regulated. You've done it perfectly. But now, what do you do if the authority, let's make it a police officer or a security agent, goes in to a situation using that law, hears what this person is saying, and just doesn't like it? I don't like that message. I don't like what you're doing. What if you're burning a draft card in the 1960s, and your purpose is not to prevent the draft board from knowing where you are? You are burning the draft card on a stage with an audience, encouraging other people to burn their draft cards. And you are doing so as an expression of symbolic speech to encourage protesting the Vietnam War. And what if the law has been written not to protect the military or the draft, but to prevent protesters from using their draft card to protest against the Vietnam War? And what if those legislators say this before they vote on it? Let's stop those hippie protesters from burning a draft card to protest the war. That's not over-inclusive or under-inclusive, and that's not content discrimination. It's viewpoint discrimination. What is the nature of your message? I go to this detail, and there are a series of cases that we can talk about and analyze to look for this. And it's the secret to truly understanding what was going on in the court's First Amendment decisions from 1986 to the present, but especially from 2000 to the present. They are looking for a way to say, we are going to uphold the laws we want to uphold, we're going to strike down the laws we want to strike down, and we're going to do it by almost making it impossible to regulate speech. This is a way for the majority of the court in this period from 86 to the present to be very protective of free speech, and to do so by focusing in like a laser beam on the line between speech and conduct, and using these techniques of over-inclusive, under-inclusive, viewpoint discrimination, content discrimination, to force the government to narrowly tailor or closely tailor their law and prevent these laws from being upheld as constitutional. And we will see that in the RAV hate speech case. Here are categories that you could have covered. Here are categories that you didn't cover. I can find 4 different ways for eliminating this law. And I can do so in a way that will make it almost impossible for you to write the law. What we are talking about here is a larger concept that we will talk about when we talk about symbolic speech. And that is, what is the purpose of the lawmaker? Those are tools that the justices can use. But what they're really doing is they're saying, I'm going to look at your law. The law is probably going to regulate messages. It's going to regulate conduct. It's going to regulate conduct that has an expressive message. That law is going to be designed for a certain purpose. And all of this, expanding the use of Chaplinsky, which really was about the creation of fighting words and the creation of a carve out to the First Amendment. And if you just look at Chaplinsky in its most narrow sense, it's not a big case in the 1940s. It's one of the Jehovah's Witnesses cases. But for me, trying to teach and understand the First Amendment and trying to discuss with my student the First Amendment and their meaning and to analyze it, it's a central way of looking at the differences between protected speech, unprotected conduct, the line between them, and the need to be absolutely on that line, closely or narrowly tailored. And where the court, I think, gets it right is in Cohen versus California, a symbolic speech case written by John Harlan in 1971. It's a case of a man who went into a courthouse, I have to be careful here, with a leather jacket with 3 words on it. The first word began with F and had 4 letters. When he first went into the courthouse, he had the jacket over his arm. And then he put the jacket on and walked through the courthouse. And he was arrested for disturbing the peace. Was that constitutionally protected, or was that arrest supported under the 10th Amendment? When John Harlan looked at this, the key to his understanding was to say, I'm going to look at that phrase, and they probably arrested him for the first word beginning with F. They probably were using an idea of obscenity. But I don't see the first word. I see the 3 words, F the draft. That's a message. And he said, I am here to protect a protester's right to convey a message symbolically. Now, it doesn't mean I'm always going to vote for the protester, he says. I'm going to have a higher level of scrutiny to protect protesters so that there will be limits to what I will accept. But what he's saying is, unlike the draft card burner, David O'Brien, who was burning his draft card in front of his audience to protest the Vietnam War and encourage others to protest the Vietnam War. And the court said what they were protecting was the operation of the draft and the military. They were protecting conduct. So we will allow that to happen. We're not going to worry about the message. They ignored the clear evidence provided by a professor at the University of Massachusetts named Dean Alphonse Jr., who went back to Congress's debate about this amendment to the military draft regulation and discovered that the reason they passed it was they were targeting those protesters. They wanted to put people in jail for burning a draft card to protest the Vietnam War. They were going to put them in jail for the message that they were offering. They were violating the First Amendment. The Warren Court doesn't look at that. They just look at the draft and the regulation and the constitutional power of the government. But Harlan is not going to make that mistake. He's not going to fall into that trap. He's going to say, this fellow had a message. Yes, it was obscene, possibly. It was certainly offensive, but he had a political message and he was protesting it. And so I'm not going to hold the law to a reasonableness test. I'm going to hold it to a more exacting scrutiny test. It's going to be that jurisdiction has to have an individualized and particularized interest in enforcing the law. If you target speech, you've got to prove this is the only possible way to achieve your goal. What's he saying? There was no breach of the peace. Nothing happened because he did this. You're putting him in jail because of the message he wanted to offer. I won't allow that to happen. So where do we end up? We end up in Texas, where a fellow named Gregory Johnson can't get anybody's attention. He's outside of the Republican National Convention as they're going to nominate Ronald Reagan, for the presidency that he would win. And Gregory Johnson, after trying all these possible ways to get people attention, came up with an idea. What if in Dallas, Texas, in front of a bunch of burly Texas Rangers, not the baseball team, the law enforcement officials, what if he took out a gas can and a lighter and an American flag and he burned an American flag? What would happen if they arrested him for what he did? He didn't say anything. He just burned the American flag, made the audience uncomfortable. Can you uphold this arrest, knowing that perhaps that audience is using a heckler's veto against him by making themselves uncomfortable? Is it possible that they're arresting him for the quality of his message? Is it possible that this is Cohen versus California and not United States versus O'Brien? Well, an odd thing happened in this case. This was in 1989. Scalia had been on the court for 3 years. William Rehnquist, the Chief Justice, had been Chief Justice for 3 years. William Rehnquist came to the court, Chief Justiceship, having been on the court since 1971. He was so conservative, he was known as the Lone Ranger. He loved to write solo dissents. And Rehnquist, as a Chief Justice, continued to write his solo dissents. He was going to support the right of the state of Texas to put this fellow in jail for burning the flag. But a curious thing happens on the court when the Chief Justice is not in the majority. A majority wanted to uphold Johnson's right to burn the flag. And when the Chief Justice is not in the majority, the senior justice in the majority gets to assign the opinion. Well, the senior justice in that majority was William Brennan. And why? It worked this way. John Paul Stevens, who was normally with Brennan, who served in the Navy in World War II, Chief Justice Rehnquist served in the Air Force. John Paul Stevens uncharacteristically voted with Rehnquist and said, the flag is special, you can't burn it, I'm going to protect it. But Rehnquist did not get a majority because the originalist, Antonin Scalia, switched sides and voted with Brennan. And this was a case when he said, I don't like what Johnson has done, but the framers, most especially Sam Adams and John Adams and the people in the Boston Tea Party, they would have loved this kind of protest. They probably burned the British flag. I think, using my originalism, I've got to vote for the right of free speech to promote that symbolic speech message. And so Brennan gets to write the opinion. And what does he do? He says the flag is sacred, but because of that, it is a bedrock principle of the First Amendment to protect even the most sacred of symbols. We can't let the government target messages. We can't let the government prevent people from protesting. Much as we dislike it, we have to support this. There was a big debate about this. Now, he went on in this opinion to say what's really wrong here is that Texas, the state, is protecting the American flag. So bring us another case. Bring us an American arrest, American government arrest for the same thing. Well, it happened a couple of years later, Eichmann versus the United States. And the majority was exactly the same. Well, not only can't the states do this, but the federal government can't do it. What Texas versus Johnson tells us is the full meaning of Chaplinsky is if you target speech with your law, message, or content, you're probably going to lose because you can't use the law to undercut a right that begins, Congress shall make no law abridging freedom of speech. So if you target the law, we're going to use our highest level of scrutiny. We're going to look for an individualized, particularized interest, and we're going to stop you from doing it. If you want to write a law like that, make sure it's all about conduct, and then we can use a lower level of scrutiny. I think when you have Chaplinsky, you have the notion of using history, you have the notion of what to do about activism and self-restraint. When you have all of these tools, you'll be able to go back to my first part of the first lecture and understand how to do IRL, PRAC, and better be able to brief cases and then debate with each other what these cases mean.